Welcome to the Deep Dive. We take the wealth of your sources and distill them into the core knowledge you need, complete with the surprising facts and crucial context. Today, we are plumbing the depths of ancient legal and social structures. We're focusing not just on crime, but on what really constituted a foundational and abhorrent offense, the kind of violation so serious it seemed to threaten the very existence of the community.
That's right. Our mission today is, well, it's deeply structural. We're analyzing the sources you provided on the laws of Athens and Rome to contrast how these two sort of leading ancient societies defined authority, where they drew the line on betrayal, and what legal extremities they thought were necessary, to purge society when those lines were crossed.
And we're zooming in specifically on those bedrock beliefs about the family unit itself. We've got the Roman familia on one hand and the Athenian concept of philia, which is more about kinship solidarity, on the other. How did these really different foundations end up dictating the laws around, say, homicide or even political misbehavior?
And setting that stage is absolutely crucial because these sources, they really let us analyze the exact hierarchy of offenses back then. The most serious crimes weren't always what we'd expect. Often they were the ones that violated the fundamental social or maybe even more importantly, religious contracts, not just the civil laws protecting an individual person.
Ah, okay.
And in Rome, you really see this tension playing out between ea ius divinum, so divine law, and eius humanum, which is civil law. And it manifests most clearly, I think, in the domestic sphere. That domestic authority was seen as like the first and most sacred line of law.
Okay, so let's unpack that Roman legal bedrock then. When we talk about authority in Rome, we really have to start with the concept that just permeated and defined their society for centuries. Patria potestas, paternal power. And this wasn't just, a son respecting his father. It was this comprehensive, lifelong legal and spiritual jurisdiction.
It truly was the foundation. The authority of the paterfamilias, that's the male head of the household, was, well, essentially absolute. Legal historians like Henry Maine really emphasize that relationship in archaic Rome was exactly limited by this power. The patria potestas was the defining status. It was the legal fiction, really, that everything else rested upon.
And when we say absolute, how far did that go? I mean, did it really encompass the power of life and death, and did it ever end, or was it just forever?
It was perpetual, basically. And yes, it potentially encompassed life and death, certainly in early law. It covered every single person under that specific authority. Didn't matter their age or their status, wife, children, grandchildren, even adopted relatives. They were all under the same power. Or they would have been if their direct male ancestor, the one holding the power, had lived long enough.
Wow.
And critically, this power wasn't just civil, it was inherently sacral, religious. The paterfamilias wasn't just the boss, he was also the chief priest for the household gods, the Lauras and Penates.
Right, right. So a violation of the Patria potestas wasn't just like disobeying your dad. It was fundamentally a violation of divine law, too.
Exactly. It was seen as a violation of the Pax Deorum, the peace of the gods. And maintaining that peace was absolutely essential for the survival and the health of the whole community. If the gods were angry because the domestic order was messed up, the entire Roman state could suffer.
Okay, that makes sense.
Therefore, the most abhorrent crimes, the ones they truly feared, were those that struck directly at this vertical authority structure. Where potestas began, that's where kinship began. And where potestas ended, kinship ended too. Simple as that. Legally.
And that structural rigidity, that clarity, it immediately leads us to their system of kinship, doesn't it? What the Romans called agnation.
Precisely. Kinship, or agnation, it's the legal framework that literally starts and ends with potestas. You can almost think of patria potestas as this massive, legally enforceable umbrella. Everyone standing under that specific umbrella is legally kin. Everyone outside it, doesn't matter if they're related by blood, they are legally disconnected from that line of authority, and importantly, succession.
That distinction is critical. So
Yeah.
hang on. If I, as a paterfamilias, emancipated my son, basically set him free from my potestas, did that really strip him of kinship? I mean, in the human sense, he's still my son, right? How did the law handle that apparent contradiction?
Well, for archaic Roman law, the legal status completely trumped the biological tie. It's stark, but true. An emancipated son, by definition, was removed from the potestas. And the consequence? He lost all rights of agnation. That means no inheritance rights from his birth family line, legally speaking.
Wow, okay.
But conversely, adoptive relatives, they were fully brought under the potestas. And so they counted entirely among the kin. They were treated identically to blood descendants in law.
So the legal tie, the potestas, was literally more sacred, or at least more legally significant, than the actual blood tie.
You got it.
And this principle, this is what leads to that really surprising exclusion you mentioned earlier.
Yeah.
The descendants of females, they end up outside the limits of this archaic kinship structure. Why was that?
Yeah, it is genuinely counterintuitive to us now, but it made perfect legal sense within their system, in early Rome anyway. Think about it. If a woman married under the stricter forms of marriage, she often passed into the manus the authority of her husband or her husband's paterfamilias. Her children, therefore, fell under the patria potestas of their father's family line.
Okay.
Now, if those same children were also allowed to remain legally kin, agnates, to their mother's father, so, under his potestas line, simultaneously, the whole system would face an existential threat. It would become unworkably complicated.
You mentioned the risk of society being confounded. Can you, ground that for us? What practical problems would actually arise if one person was somehow subject to two different patria potestates at the same time?
Oh, the problem is one of absolute jurisdiction. Remember, the Roman family was conceived almost as an imperium, an imperio like a little kingdom within the bigger commonwealth, governed by its own very specific internal laws and authority.
Right.
So, if a man was subject to two supreme authorities, let's say his paternal grandfather's potestas A and D, his maternal grandfather's potestas as well, who has the ultimate say, who would have the power of life and death over him? Who's responsible for performing the necessary legal rites, like approving his marriage or handling his burial ceremonies? Who controls his property?
You'd have competing authorities. Chaos.
Exactly. If both could claim authority, the entire social and religious order, which depended on clear lines, would just collapse into confusion and conflict.
So, to keep that absolute vertical clarity of authority, they basically had to exclude the maternal line from agnation. Avoiding those overlapping lines of power wasn't just neat, it was a structural necessity for them.
Absolutely. The system demanded singular, unbroken, vertical jurisdiction. And this total domestic authority, as you can imagine, had really profound repercussions for things like property and stability.
Okay, let's link this absolute authority now to how wealth was actually managed and passed down through succession.
Right, so this structure creates the fascinatingly rigid system of sui juris, which literally means his own heirs. These are the people already in a man's potestas who automatically become legally independent sui juris the moment he dies.
So they inherit automatically, not because they're named in a will necessarily.
Right, precisely. Their inheritance isn't like a gift granted by a will. It's an automatic legal consequence of their change in status. They simply step into the legal independence and the associated property rights that the deceased person formerly held over them. They become heirs in equal shares, essentially stepping into the deceased's shoes collectively.
They inherit because they're freed from that legal control.
Exactly. But, and this is a big but, the same civil law, the Neuner Civil, was so rigid that it created what later Romans saw as profound injustices, which is why the praetors, the magistrates, later had to step in and modify it extensively using their equity jurisdiction.
How so? What were the big exclusions?
Well, the strict adherence to the line of potestas completely excluded any emancipated children. They were now legally outside that umbrella, remember? So no inheritance rights under the old civil law. And it also excluded all relatives on the wife's side unless the wife herself had been brought completely under her husband's power through that strict form of marriage, being in manu. Otherwise, her family was irrelevant to his succession.
Wow. That really illustrates the sort of cold, calculating focus of archaic Roman law, doesn't it?
Mm-hmm.
Property and civil status were just maintained strictly within that rigid, unbroken line of patriarchal authority. It seems like the whole system was designed purely for legal stability, even if it trampled on what we'd consider normal family sentiment.
It absolutely prioritizes the abstract legal fiction, the potestas, over the biological reality in many cases. It really cements this idea that order comes from the top down through one single, almost sacral head of the family. And this deep structural belief, this vertical structure, stands in really stark contrast to the Athenians. Their focus, when it came to family crimes, shifted much more from vertical obedience to, well, horizontal loyalty and solidarity.
Okay, so we shift now from Rome, where the paterfamilias was almost judge and priest in his own home, to Athens. Here, the state gradually got more involved in matters of bloodshed, but the foundation, initially at least, remained the kin group, right?
Vengeance for killing was primarily the job of the victim's relatives. That's the legacy, mostly, of Draco's law on homicide, which was actually maintained even after Athens became a democracy. The main way you prosecuted a killer was through the dekiphono, the homicide suit, and the sources show there was a specific range of relatives usually going out to about the degree of first cousin once removed of the victim who had not just the right but the sacred duty to prosecute. Vengeance was really seen as a family affair, almost a purification ritual for the family line.
But the real moment of crisis, the point where Athenian society seems to define an act as truly deeply abhorrent, is when that violence happens within the family. When the killer is a kinsman and the prosecutor has to be a kinsman.
Yes. That is the ultimate test of the Athenian social fabric. Now we enter the realm of impiety, agnosization is the Greek term. The expected Athenian response when a kinsman was somehow involved in a death was typically not prosecution, but absolute solidarity. To actually prosecute your own father for homicide, for example, that was widely considered a massive transgression against piety, a kind of spiritual pollution in itself.
Wait, so that sounds like a societal contradiction? Murder itself creates pollution, but prosecuting the murderer, if he's family, can be even more polluting.
That's the philosophical tension exactly. The murder itself pollutes the bloodline, sure. But the act of destroying the unity of the philia, the family solidarity, the kinship bond that was often seen as a graver offense against the gods, and the whole social structure.
And we have a classic example of this conflict playing out in Plato's dialogue, the Euthyphro, don't we? What does that case study really tell us about the hierarchy of what Athenians found truly abhorrent?
Oh, the Euthyphro case is perfect. It's absolutely perfect because it shows three distinct lines of objection that Euthyphro's own family raised against him when he tried to prosecute his father for homicide. The backstory is, Euthyphro's father had bound up a hired laborer who had apparently killed a household slave in a fit of rage and left him in a ditch while he sent someone to Athens to ask the religious authorities what to do. But the laborer died of exposure and hunger before the messenger got back.
Okay, so it's already a legally murky situation. What was the first objection the family raised?
Well, first, they debated the basic facts and causation. They argued the father didn't physically kill the laborer. The man died from neglect, from exposure. It wasn't a direct act of violence.
Okay, plausible deniability, maybe. What was the second point?
Second, they pointed out that the victim, the laborer, was himself a killer. Ajrafovnu. The implication being, maybe this guy wasn't really worthy of all this legal fuss or sympathy. Anyway, he wasn't an innocent victim.
Right, trying to diminish the victim's status.
Exactly. But the third objection, and this is the one that really gets to the core of Athenian values, was that prosecuting one's own father for homicide amounts to impiety, anovjon, regardless of the specific facts of the case. Even if the father had directly killed him, even if the victim was innocent, a son suing his father was simply wrong.
So, they were essentially saying the procedural violation, the act of a son taking his own father to court for murder, was a greater offense against the divine and social contract than the potential murder itself.
Yeah.
That completely flips our modern logic of individual justice on its head.
It absolutely does. It elevates the unity of the family, the philia, above the singular act of killing. You see this reflected elsewhere, too. Demosthenes, the orator, mentions this deeply ingrained belief when he says that if you suspect a philis, a kinsman, a friend, someone within your circle of homicide, you don't prosecute him yourself, you leave that terrible task to his enemies, or perhaps to the actual aggrieved kin of the victim if they aren't also your kin.
Wow.
Family unity was paramount. Shattering it through intrafamilial prosecution, that was anathema. It was seen as a source of pollution far greater in some ways than the original crime.
And this intense horror surrounding intrafamilial violence and the pollution it creates, this must be why we see such powerful explorations of it in their tragedies, right? Especially something like Aeschylus's Oresteia trilogy. It puts that whole generational curse, that cycle of violence, right at the heart of the developing civic state.
Oh, the Oresteia is the literary embodiment of this exact structural conflict. You have this relentless cycle of murder. Agamemnon sacrificed his daughter Iphigenia, then he's murdered by his wife Clytemnestra, then their son Orestes is basically obligated by Apollo to avenge his father by killing his own mother.
It's brutal.
It is. And the plays stage this clash between the older, almost silent obligations of blood ties and revenge versus the desperate need to establish some kind of stable, rational civic order to stop the killing. The cycle is literally one of blood guilt demanding purification, which then creates more blood guilt.
And the ultimate resolution in the trilogy, that's the establishment of the Areopagus court, isn't it? The state, represented by Athena, finally steps in to break that endless cycle of kin-based vengeance.
It does, yes. But even that resolution is kind of tainted by the horror that came before. Athena establishes the Areopagus, the court on the Hill of Ares, specifically to judge Orestes. It moves the dispute from the realm of private, unending blood feud into the sphere of public regulated law. That's a huge step for the Pelops.
Right.
But even after the civic resolution, this acquittal of Orestes by a tied vote broken by Athena, the audience is left with this heavy feeling, this tragic sense, as scholars put it, of a man being mired in an existence determined by a past over which he has no control. Even the goddess Athena herself seems to confirm this grim reality. The errors, the sins of former generations require punishment, often working themselves out through what feels like a silent, inevitable doom, even if the court provides a legal solution.
So the underlying belief kind of persists.
Yeah.
Certain sins, especially within the family, pollute the entire community across generations. And while civic law can try to manage the legal fallout, that spiritual stain, that miasma is much harder to erase. This deep fear of structural and kinship pollution really guided the Athenians.
Exactly. And now that we've seen the Roman focus on that vertical authority of the paterfamilias and the Athenian focus on this horizontal solidarity of the philia, we can maybe compare the ultimate legal mechanisms they each used to try and purge their societies of these foundational threats.
Okay, so we've established that the crimes that really shook these societies were the ones violating their core structural beliefs, whether it was that Roman vertical authority or the Athenian horizontal kinship. Let's look now at the really extreme measures the state used to, well, excise or redefine those threats, starting back in Rome with their early forms of capital punishment.
Right. The earliest Roman legal mechanisms we know of, like those mentioned in the Law of the 12 Tables, they were brutally direct. They seem intended to physically purge the polluting element from the community. A good example is the punishment for thieves caught red-handed in flagrante delicto. For them, the punishment was capital.
Capital, so execution. Or was it more complicated than that, especially for free Roman citizens? It wasn't just death, was it?
No, for a free man, it was a really complex process. It seems designed not just to punish, but to destroy the individual's civic status, while also satisfying the victim's claim directly. The process apparently involved a public whipping first, and then the thief was solemnly assigned the term is edictio by the magistrate directly to the man from whom he had stolen.
This edictio, it sounds like something more than just a fine, obviously. It sounds like a complete destruction of your civil status being handed over like property.
It was precisely that. Now, legal scholars debate the exact status. Did this edictio make the thief literally a slave of the victim, or was it more like a highly constrained form of debt bondage? But either way, the practical result was similar. The free man lost his independence, his legal personhood, essentially, and was physically transferred to the victim as a form of restitution.
And for a slave caught stealing.
Well, a slave already had no real legal status to lose in that sense. So for a slave caught in the act, it was simpler. Whipping and then execution. The state basically authorized the victim, or the authorities, to seize physical control in this highly coercive way. Purge the problem.
That is incredibly harsh. But you mentioned this extreme cruelty was eventually tempered. That suggests a shift in how Rome viewed these kinds of internal threats over time.
Yes. Thankfully, the severity was softened quite significantly in later periods. The Praetor's Edict, reflecting changing social norms and perhaps economic realities, shifted the penalty away from physical edictio and capital punishment for manifest theft. Instead, it established a civil action, a lawsuit, where the thief could be sued for 4 times the value of the stolen goods, the actio furti manifesti quadruplum.
Okay, moving from physical bondage or death to a 4x fine. That seems like a massive shift. How does that change the nature of justice, or who it affects?
Well, it completely changes the practical impact and perhaps the targets of justice. Physical assignment, edictio, that's a punishment that disproportionately hammers the poor, right? People with no resources to offer restitution would face debt bondage or worse. But a massive fine, 4 times the value, that's only really a viable punishment if the thief actually has assets to pay it.
Ah, right.
So you could argue this change effectively decriminalized minor theft for the wealthy, or at least shifted it firmly into the civil sphere. An offense that was once treated as a physical, polluting threat requiring removal from the state becomes more like a solvable financial transaction. The state moves away from purification by purging the body and toward purification by payment. It probably reflects a more complex, urban, and financially sophisticated society evolving.
That provides really important context for Rome's legal evolution.
Yeah.
Now let's pivot back to Athens. How do they handle their primary form of foundational threat, which, as we discussed, often seem to be political rather than purely criminal?
Yeah, The nascent Athenian democracy, especially after periods of tyranny, was constantly worried about ambitious leaders who might try to overthrow the system and become tyrants themselves. So they needed mechanisms, sometimes extreme ones, to protect the democracy itself, often prioritizing civic safety over individual rights as we might see them.
And this is where we get that interesting concept of privilegium. It's a Roman term the sources use, but it captures that Athenian principle of imposing a specific, unique inconvenience or penalty on just one person, not for a crime committed, but to protect the greater good. Right?
Exactly. Cleisthenes, the founder of the democracy, is said to have incorporated principles like this to basically eliminate dangerous rivals without resorting to the bloody civil conflict, the stasis that had plagued Athens before. And the classic example, the one everyone knows, is ostracism.
Right, ostracism. We hear about it a lot, but we often forget how sort of philosophical and mechanically intricate the actual process was. It wasn't just some arbitrary mob rule, was it?
Oh, far from it. Ideally, anyway. Ostracism was meant to be a measured collective act of political self-defense by the citizen body. Before a vote on ostracism could even happen, the council, the bull, and the main public assembly, the ecclesia, had to formally debate whether the state was currently facing a danger menacing enough to even justify using this exceptional measure. Only if they voted yes, only then was a specific day set aside for the actual ostracism vote itself.
And that vote involved thousands of citizens, right? Voting secretly with their pottery shards, the ostraka. And crucially, the person being voted on wasn't actually accused of a specific crime.
No, that's the key. There was no specific charge, no trial in the usual sense. Ostracism was aimed at individuals who had simply become too powerful, maybe too influential, perhaps too wealthy, or just someone whose ambitions seemed to pose a kind of gravitational pullback towards tyranny or factional strife.
So you could be a good guy like Aristides the Just and still get ostracized.
Yeah, exactly. Aristides is the classic example. He was apparently ostracized not because anyone thought he was corrupt or had broken a law, but simply because his reputation, his influence was becoming so overwhelmingly great that some Athenians felt it unbalanced the fragile democracy. It was a conscious, albeit harsh, decision by the collective state to preemptively neutralize a political threat before he could even theoretically commit a crime against the Constitution.
It really is the ultimate expression of the state prioritizing its own stability, its own survival, by essentially sacrificing an individual's citizenship, forcing them into exile for 10 years.
And you really see the horrific contrast when that mechanism of legal controlled purging fails, or when it's deliberately bypassed and replaced by pure partisan violence. The downfall of the democracy at the end of the Peloponnesian War led directly to the terror imposed by the 30 tyrants.
Yeah, the sources paint that as a moment of complete breakdown of any legal order.
Utterly. The 30 immediately executed their political opponents, people like the orator Antiphon and the general Archeptolemus, often without real trials. And the subsequent persecution of known Democrats, often based on denunciations by informers like this man Agoratus. Lysias, in one of his speeches prosecuting Agoratus later, called Agoratus's actions the beginning of the whole evil business of the 30s' reign of terror.
So it's a stark difference.
A huge difference. Ostracism, in theory, was the constitutional removal of a potential threat by the whole body politic to preserve itself. The rule of the 30 was the criminal execution and persecution of opponents by a narrow, installed, factional elite. That wasn't purging, that was the civil war itself.
Okay, shifting back to Rome one last time. How did the Roman state use legal mechanisms to redefine an individual's status, specifically through exile? Because it seems like the Romans viewed exilium, exile, a bit differently than just banishing a threat.
Cicero gives us a really fascinating, maybe slightly legalistic technical distinction here. He explains that Roman exile, often, wasn't technically a punishment prescribed directly by law in the same way execution was. Instead, it was often framed as an escape route, a way for someone facing a capital trial or maybe severe public disgrace, ignominia, to avoid the final penalty. They sought refuge in exile, almost like fleeing to a sanctuary.
Huh. So the state didn't formally kick you out. You sort of chose to flee to avoid something worse, and they just accepted that. It maintains a kind of legal fiction.
Exactly. According to this view, the fugitive lost their Roman citizenship not because a law formally stripped it from them, but through their own act of abandonment specifically, by taking up citizenship in the new state they fled to. Rome was quite careful legally to maintain this fiction that it didn't actively strip its citizens of their core status. It suggested the citizens chose self-preservation over remaining in Rome to face the consequences. It respects, maybe in its own slightly cynical way, the foundational importance of Roman citizenship. You leave it, it doesn't leave you.
Fascinating. Okay, finally, we have Plato. Looking back at the Athenian system he knew, and proposing a really radical purge for something we might just consider a procedural flaw today. Excessive litigation. Suing people too much.
Yes, Plato, especially in his later work, The Laws, developed a profound dislike for what he saw as the endemic litigation in Athenian society. All the lawsuits, the constant legal wrangling, he viewed it as a sign of corruption, a decay of civilization, maybe even a remnant of barbarism. He saw it as sowing perpetual conflict, internal strife stasis within the city.
And his proposed punishment was death. For suing people too often. That seems truly radical, even for Plato. Why did he view that as a foundational crime, something worthy of the ultimate purge?
Well, for Plato, remember, the state, the polis, wasn't just a political entity. It was supposed to be the embodiment of the highest moral and philosophical ideal. So any force that systematically created internal conflict, instability, and disharmony was, in his view, a crime against that ideal state order itself.
So the person wasn't just annoying their neighbors.
No. In Plato's ideal state, the perpetual litigant, the person who continuously sows discord using the tools of the law itself, wasn't just being difficult. They were actively destroying the philosophical foundation, the harmony of the republic. Such behavior wasn't merely an inconvenience, it was a destructive force against societal peace and the pursuit of virtue. And to protect the purity of the state's ideal form, it demanded the ultimate penalty.
Wow. It's just a powerful testament, isn't it, to how profoundly the legal and the moral orders were intertwined in ancient thought, where a fundamental lack of peace, whether that was domestic peace within the familia, civic peace within the polis, or even philosophical harmony, was considered truly an abhorrent condition requiring drastic measures. Tag outro.
Absolutely. This deep dive, I think, has really shown us a profound divergence between these two societies, and it seems rooted right in their definition of the family unit. Roman law defined order through that absolute, almost sacred vertical power of the paterfamilias, and the strict maintenance of property lines through agnation. For them, betrayal meant violating that chain of command, an act which could potentially upset the whole cosmic balance, the pax duorum.
Yeah, while Athenian law, conversely, seemed much more focused on the pollution caused by kinship betrayal, that impiety of turning against your own fellows, and also on the rigorous purging of political threats to maintain the democratic and civic order. Athens was deeply concerned with horizontal solidarity and civic survival, Rome with vertical authority and divine peace.
And we've definitely established that in antiquity, the deepest legal anxieties, the things that prompted the most extreme responses, often lay not just in the act of violence itself, but in who committed the offense, or, crucially, who brought the charge. It was the violation of the defined social structure, whether that was the absolute power of the potestas or the expected solidarity of the filia, that was truly horrifying to them.
Which brings us to a final provocative thought for you, the learner, to maybe consider long after we wrap up this deep dive. In societies where the ultimate goal isn't necessarily individual rights as we conceive them, but rather total stability, whether that stability is defined as pax, that peace between gods and humans like in early Rome, or political survival like in democratic Athens, which authority ultimately holds the sacred right to draw the boundaries of what constitutes an unnatural crime. Right. Is it the absolute individual family head, the paterfamilias, or is it the sovereign collective state? Where does that ultimate power to define the abhorrent truly lie?